So an emergency application was made to the Supreme Court for them to review the state of New York's defiance of the New York State Rifle and Pistol Association v. Bruen decision. And now the state of New York has submitted its arguments for why the Supreme Court should not review this issue. So let's talk about this. But real quick, before we jump into this video, I want to thank the sponsor of this video, which is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll leave a link to them down in the details section. Also want to mention right now that the Gundy's Award is now open for you to vote. Last year, we won the top two-way voices. This year, I'm in the same category, so I would love to win 2 years in a row. If you would like to vote for me, you can use the links down below in the details section and also in the comment section. And you can vote every single day. You can vote in 15 categories. Again, vote every single day, and you are entered to win a bunch of prizes, including a free trip of your own to attend the Gundy's Award with us. As I mentioned in the intro, Gun Owners of America has filed an emergency application up to the Supreme Court seeking immediate emergency administrative relief in the Antioch v. Negrelli case, which is a challenge to the state of New York's new concealed carry law, the CCIA, which the state of New York passed in direct defiance to the Supreme Court's recent ruling in Bruen. Last week, the Supreme Court issued a request for the state of New York to file a response in opposition to that emergency application and to answer essentially why the Supreme Court should not review this case. Well, the state of New York has filed their response, arguing why the Supreme Court should not review this issue. This case arises out of a lawsuit filed by GOA against the state of New York because of the Concealed Carry Improvement Act, which again they passed in direct defiance to that Bruen decision. Because of how this law directly violates the Second Amendment and the rights of residents in New York, and also how it directly goes against the Bruen decision, GOA filed a lawsuit against the state of New York. That is the Antioch case. The case was originally heard before Judge Sotheby in a district court in New York. He heard GOA's request and ultimately granted a preliminary injunction and put a halt on various aspects of the CCIA. That included him striking down portions of the law like the good moral character standard, also the catch-all sensitive place restrictions that were in the CCIA, along with other provisions as well. After that, New York decided to appeal that preliminary injunction that was granted by Judge Sotheby, and they sought an appeal up to the Second Circuit. They also requested the Second Circuit grant a stay on that judgment. Ultimately, the Second Circuit granted that stay, which prevents Judge Sotheby's preliminary injunction from having any impact. Now, instead of waiting around for the Second Circuit to ultimately decide to get to this case and to hear this issue, GOA went ahead and filed an emergency application up to the Supreme Court. This is all being done through what is called the shadow docket. It's kind of a more informal mechanism, procedural mechanism that you can get to the Supreme Court. The emergency application asks the Supreme Court to vacate that Second Circuit granting of the stay. Therefore, if the Supreme Court grants that request and vacates the stay, Judge Sotheby's preliminary injunction would therefore go into effect. This emergency application was filed to Justice Sonia Sotomayor, who is the justice responsible for reviewing emergency filings and applications which come out of the Second Circuit. And as I've mentioned in prior videos, just because she's initially responsible for granting, denying, or referring that emergency application to a full court and for a full court vote, that doesn't mean that there's not other remedies available to GOA. If Justice Sonia Sotomayor decides to not take action on this emergency application, denies the application, then GOA could go to any of the other justices that they want, like Justice Thomas, and request that that justice grant the emergency application. However, what ended up happening here in this issue is that Justice Sonia Sotomayor decided to request a response in opposition from the state of New York, and the state of New York has now filed their response. In their opposition, the state argues that the Supreme Court should deny the emergency application because first, the Supreme Court is not likely to grant review of any upcoming decision that the Second Circuit issues in this case. Second, the state of New York argues that there is no evidence that the Second Circuit committed an error when they granted this stay. And finally, they argue that the plaintiffs will not suffer irreparable injury because of this stay. And if you watch my last video, I pretty much speculated what the state of New York would argue, and I was pretty much 3 for 3. Those are exactly the type of arguments that they made in their response. New York first argues that in their first argument, the petitioners here, the applicants, the plaintiffs, cannot make the exceptional showing that this court is likely to grant a writ of certiorari to review the Court of Appeals' forthcoming determination regarding the district court's preliminary injunction. Indeed, they state, although applicants acknowledge this requirement for vacature of a stay, They offer no explanation as to how it has been satisfied in this case. New York goes on to state that applicants could not carry the burden to make this showing in any event for several reasons. Review is premature given this case's interlocutory posture, and although this case concerns important issues, further percolation of the relevant issues in the lower courts is needed to inform this court's review. So here the state of New York is making the argument that the Supreme Court should not grant the emergency application right now because the Second Circuit should be given the opportunity to first review these issues and to handle these arguments that are being made. They claim that the Supreme Court taking up this issue is premature, even though it presents a significant constitutional question, which is whether or not the CCIA is in fact consistent with the Second Amendment, the various provisions within it are consistent with the Second Amendment, and also whether or not it goes directly against what the Supreme Court just ruled in Bruen. Second, New York argues that the Second Circuit did not commit an error when they granted the stay on the Judge Sotheby preliminary injunction. They argue that New York is likely to prevail on appeal because they believe that the district court's decision is riddled with errors on threshold issues of standing, that it misapplies the Bruen requirements of showing historical evidence to support every challenge, as they're saying. They are saying that these types of issues in question the CCIA, not all of them are covered by the Texas Second Amendment. And also they argue that the decision down below by Judge Sotheby applies a rigid analytical methodology that impermissibly turns Bruen into a regulatory straitjacket. There they are referencing some language within the Bruen decision. Here in this section, New York argues that the stay was appropriate because the district court misapplied Bruen. New York argues, for example, that the good moral character standard and that requirement in the CCIA does not implicate the text of the Second Amendment, and therefore they believe that they do not need to present historical evidence dating back to 1791, which again is required under Bruen. Finally, New York argues that the emergency application should not be granted because the plaintiffs will not suffer an irreparable injury. The state of New York argues that the negative impacts of the CCAA may have really only impacts on the plaintiffs at best, but they also argue that those injuries are purely speculative. And for example, they argued that the applicant here, the petitioners here, one of them was in relation to concealed carrying at a church, and they said that there was only speculation of how the CCAA would impact them. So they're trying to say that the arguments made of the impact of the CCAA on these specific individuals is just purely speculative. However, at the end of the New York arguments, they state that if this court disagrees and determines to vacate the stay, it should do so only with respect to applicants, which would suffice to prevent any alleged injuries that applicants may have standing to assert. So here they're saying, well, Supreme Court, if you agree that this emergency application should be granted, that the stay should be vacated of the Second Circuit, you should only vacate it to these specific named individuals in this lawsuit. You shouldn't essentially let it apply to all the residents in the state of New York. They're trying to keep this as limited as possible. So that was New York's opposition to the emergency application that was filed up to the Supreme Court. We will now have to wait and see what the court ultimately decides to do. Justice Sonia Sotomayor may already have referred this to a full court for review, or maybe she's going to decide on the emergency application on her own. But for now, the state of New York is arguing that the application should not be granted and that the stay should not be vacated, should not be lifted because the district court did not correctly apply Bruen. That is what the state of New York believes. So this is something I will definitely keep my eyes on because this has huge implications. Like I mentioned, the shadow docket here can move a lot faster. It's moving a lot faster. As you guys can see, there's a lot more things happening than the traditional Supreme Court docket system. So if anything else develops, I will definitely let you guys know. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of two-way news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation is built by armed scholars, and this nation will be maintained by armed scholars.